Hello class, this is Dr. Fenton. In this chapter we'll talk about a very interesting area called money laundering. So let's get started. Okay, chapter 7. Let's go to this page. Before we talk about what's at the top, let's really go to the bottom, because we need to find out what money laundering is. Now I'm sure you've heard the term and you probably already know what it is, but let's talk about a definition here. This definition can cover both legal and illegal context. So I guess even though you don't hear about it very much, there is maybe a little bit of a legal way to launder money. And we'll talk about grants in a few minutes, and that's what we're really talking about. It's okay if it's done correctly. That could get into illegal also, where you're moving money around in grants. Anyway, it is to take money that comes from one source, hide that source, and make the funds available in another setting so that the funds can be used without incurring legal restrictions or penalties. Now, the purpose of money laundering, the primary purpose of money laundering is to make the funds spendable in a context that would have been unavailable otherwise. I know when we talk about money laundering, we talk about mainly illegal activities, and that's what the focus of this chapter really is about. Now, money laundering, when you start to think about the illegal part of money laundering, there are three general steps. First, the money is deposited in a bank. It's called placement. You place your money. Next, you set up a series of complex transactions that's made to disguise the original source of the money and hide the audit trail. We'll talk a little bit about churning in a few minutes, and that's what this is doing. You're moving it from one bank to another country. You're trying to bury it so deep, it's hard to find out where did it come from. Okay, where did the source of funds come from? Third here, final step is called integration. It takes place when the money is integrated back into the legitimate money supply and made available to the money launderer. So if you're obtaining money illegally, you want to be able to spend that money, but you don't want that money that you're spending make you go to jail for that initial activity. So in some cases, and I've read a lot about this, that the money launderers, they don't mind getting the money into another legitimate business, illegal money, place it into a legitimate business, pay taxes on it, and then they can spend it. So at least they're paying their taxes. They're not going to get in trouble there, but they want to hide how it was really obtained. That's the part that is illegal. Okay? What kind of problem is this? Well, it could be 2 to 5% of the global GDP. That could be $800 billion to $2 trillion of money laundering going on every year. Quite a bit of money. And there is a government group called FinCEN. I don't think the book explains this very well. Let me show you the website. This is the Financial Crimes Enforcement Network website. It's part of the U.S. government. It's just fincen.gov, G-O-V. And they're overlooking the, anything financial, anything criminally financial. And so they talk about the statute and regulations. They give advice to financial institutions. Let's see, International is the official intelligence unit of the U.S. government. And, they talk here about Anti-Money Laundering Act of 2020. It's in our book towards the end of the chapter. And so, this is the U.S. government's way to keep an eye on financial crime and enforce penalties, sometimes criminal, on groups that participate. Go back to here. And so FinCEN's basic concept underlying their core activities is to follow the money. Follow the money. And so FinCEN partners with law enforcement at all levels of government and supports the nation's foreign policy and national security objectives. Okay, sounds good. And it can issue civil and criminal penalties. I'll let you read that. Oh, this talks about cyber cash, cryptocurrency, bitcoins, and so forth. So I'll let you read these couple pages yourself. Digital cash. And get back to money laundering here. Okay, talked about grant recipients earlier. What happens here is that, let's say a university receives some federal grant money. When it's received, it's for a certain purpose. It can only be spent on that exact purpose. Well, what universities would like to do is get some of that money and get it over into the non-discretionary spending, and so it can be spent for anything at the university, help pay for anything else. So what the university might do is charge that grant, the grant recipient, overhead, because maybe the grant recipient is using the facilities at the university. They'll charge overhead for utilities and cleaning staff and supplies and things like that. They get some of the money into the general fund of the university and can be spent for other things. Now, that can be done illegally. Probably the grant tells you the maximum amount of that can be transferred for overhead. In the past, universities got in trouble and had to pay money back because they charged too much and took a lot of that grant money and used it for general purposes. Now, criminals, besides drug trafficking, there are various ways to obtain money illegally. Bribes, protection rackets, terrorism, just a whole list of things here. Continues on the next page. Contract killing, arson, bombing, illegal logging, all kinds of things. All these crimes, if successful, have the potential to generate large pools of money whose origin cannot be explained, thus promoting the use of money laundering procedures. If you're good at obtaining money illegally, you really want to get that where you can spend it, it looks like legally, right? So as we talked about earlier, you need to convert it from illegal money into spendable money. That's what the criminals try to do. And the government's always trying to catch them doing that. Okay, that's what's going on. You want to be able to spend it, You can't just have all that cash in your house, right? We talked about the cash hoard in an earlier chapter. You cannot have this much cash just sitting around the house. Now, correspondent banking. Now, the way money's moved around the world is through banks in a lot of cases. And so, these international banks, they're interconnected. Money can be moved around 24 hours a day, right? Now, correspondent banking occurs when one bank provides services to another bank. That's how you move money around. You're connected. A bank in Europe connected to the bank in the U.S., connected to the bank in Asia, right? Move money around. Banks are on the front lines trying to identify money laundering if it exists. And they have a responsibility to do that also. Banks have invested a ton of money in software to look for activities that could be considered money laundering. Okay. And so they're right there. They know it's going through their banks. They're trying to catch it. And again, they have the responsibility to catch this. Down a little bit more, here we go. If there is a cash transaction, well, a cash deposit, let's say, above $10,000, the banks have to report that to the federal government. $10,000. There's also a suspicious activity report for transactions that could be far less than $10,000, but just look suspicious by bank personnel. So the banks, they are required to report this to the government. That's why they have the software set up to look for this, to capture it, and then report it to the U.S. government. And the government then takes it from there and does an investigation if it wants to. Bankers use a policy of know your customer guidelines. When you go open a bank account, they're asking for your ID. when a business comes to the bank, opens up, it needs the business quote ID, like corporate charter, things like that. And so banks want to know who their customers are because they know that the banks can be used to launder money, and they don't want that to happen. You can look at these forms. This is the currency transaction report the banks fill out. Here's the second page. Here is the suspicious activity report. And here's the second page. And then here's another one, international currency report. And let's talk about shell banks. Now, shell banks are generally high-risk banks that exist without any physical presence in any legal jurisdiction. And so, they've been used over the years to hide money, move money around, and so forth. But since the passage of the Patriot Act, shell banks without any physical presence in any jurisdiction are prohibited from operating in the U.S., but they can still have a relationship with a correspondent bank that operates through a U.S. bank. Something like that sort of defeats the purpose there. It says their appeal has been reduced, but if they can still operate through a correspondent bank, I think this could have been a little bit tighter, here. Offshore banks, you've heard of those. These banks operate solely to exist within international financial transactions, take care of these, and they're set up in many cases to avoid U.S. taxes. The thing about it, where these banks are located, people who live in that country cannot use these banks. They're all international transactions. Nested services. Now, these services occur when a second or third foreign bank has a correspondent relationship with the first foreign bank that might have permission to operate with U.S. banks. And so you get 3 or 4 banks deep, and those deeper banks might be shell banks or offshore banks. And so it could happen where through one bank, finally U.S. bank, you can get into the U.S. banking system. Operate mainly on the internet, and they can be difficult to regulate because they can be located anywhere in the world. Let's see, nothing on this page. Let's see here. Cash-oriented businesses. Money launderers love to have these kind of businesses. Businesses that generate actual cash can be used to take the illegal cash, mix it in with the legally earned cash, get that into the system. Yeah, pay tax on it. That's fine. At least you have the spending money. But you're hiding your illegal activity out to the side. So, currency exchanges, say taxi cab companies, and that's not so much anymore because of credit cards. Bars, restaurants, real estate agencies, that's not too much anymore. Casinos, yes. Online auctions, yes. Okay. And like we just said, the money launderers can use these type businesses that generate a lot of actual cash to then mix in and hide the illegal cash. Nothing there. Let's see, nothing highlighted there. Audit trail. This is a difficult area. It's tough because a lot of times there's not a good audit trail, or the audit trail is so confusing, so hard to dig through that you just cannot find what you're looking for. This is where the churning comes in. I mentioned that earlier. You make a deposit with illegal money. Some bank accepts it. That's not going to report you, maybe in a foreign country. And then you move it around bank to bank to bank, from country to country to country. It might end up back in the U.S. It might look, quote, legitimate, right? That audit trail is just tough to follow. Very tough to follow. And they've done it that way on purpose. Let's see. Likely sources. If there is an actual traditional paper trail, it's probably been invented, put together to avoid being identified when there's maybe a possible audit, either an external financial statement audit or a tax authority audit. And so there could be fake documents, fake employees, false invoices, all kinds of things go on to make it look like, oh, everything looks legitimate, but it's hiding the true source of the funds. Now, digital information is much more difficult to fake, to show it false. And what happens on the next couple of pages, they talk about that in depth. And you can read through this if you want to. This will not be on the exam, really. You can read through this, keyloggers, websites, and so forth. And they sort of explain it in more depth there. So I'll let you read that. Yeah, it keeps going. And continues to go. All right, and here we go. This is just some general information. If you're dealing with someone, you want to make sure you know that person. So if it's your own business and you're going to bring in a partner or deal with a new client, you want to make sure that you verify that person's identity. And so you will need to ask for the driver's license, maybe other kind of documents to let them show you that they are legitimate. That's on the personal setting. On a business setting, thanks to the next page. Oh, you can also use social media, things like that. Everyone's looking at that these days, even when you go get a job. With a company, though, a company doing business with another company, you want to make sure, is that other company legitimate? Is this person coming to me? Are they truly an agent of the other company, right? You need to do as much as you can to verify this. There's another government agency called the Office of Foreign Assets Control. What you need to do, if it's a company you're not familiar with, is go to this website, look at the list, down here, specially designated nationals and blocked persons list. This shows you who and which companies American companies cannot do business with. So you might have a legitimate company come to you, maybe someone from another continent wants to do business with you. It might be legitimate, but the U.S. Office of Foreign Asset Control says you cannot do business with them for whatever reason. And if you do, then you will be the one that'll get in trouble. Trust, let me move this up a little bit. Trust can be used as a money laundering tool. You don't hear about this a lot, but it can be. The illegal funds are put into trust, and then maybe a trustee will then control the funds, pay money out to a beneficiary. So you have, as a forensic accountant, if you're dealing in trust, you might want to take a closer look to see if the beneficiaries do have a reasonable relationship with the grantor of the trust, whoever put the money into the trust. See what else we have. Red flags. What are the red flags of money laundering? A whole list of them, as you can see. Just the first three. It's difficult to verify the identity of a person or a company. Long delays providing copies of information that you want. Someone gives you a distant overseas address, and the list goes on. These are red flags. It does not mean, again, there is money laundering going on, but if you run into these kinds of things, you want to dig a little bit deeper. And down here. Now, in general, the accountant's role as gateway keeper. This is interesting. You, as an accountant, working with your clients, going out on an audit, if you run into suspected, or maybe you know it's money laundering, what's your responsibility? Good question. Good question. In the U.S., there's no confidential accountant-client privilege. Okay? And then, similar to the attorney-client relationship. Auditors, it says here, be careful about this, auditors have an overriding duty to the public above those of the client's interest. I would say be very careful about this. If you run into this situation, you had better contact and discuss the situation with an experienced attorney. What is it you have to do if you run into money laundering as your work as an accountant, like in a CPA firm? I would do that before you just automatically run to the government and say, look what I found. I would not do that. If you did, again, this sentence here, be careful. The disclosure of illegal activities such as money laundering is considered by the courts to be a superseding obligation. Yes, but I still would not run out and tell someone else. Get your own legal counsel to find out what you're supposed to do. But this is why few money laundering schemes are disclosed by auditors. Very few. Maybe they are being found, but the auditors say, I found this in some kind of confidential setting. I should not go tell the authorities what I found. Okay. So, very tough situation. If you find this in your CPA firm, jobs you're working on or whatever, contact your own legal counsel to figure out what to do. This up here, what I have highlighted, says, be careful about clients you take on. You need to have your own risk assessment procedures so that you know how to vet new clients. And so you need to make sure they are who they say they are, check IDs and so forth. And in the blue here, application of reasoned and well-articulated risk-based approach will justify the judgments made about managing potential money laundering and terrorist financial risk. This is something you don't want to get involved in yourself. All of a sudden you have a client that you did not know was involved in terrorist activities, money laundering. That's going to possibly get you in trouble. So vet your clients carefully. In the auditing area, financial statement audit area, very little is given in audit standards about what to do. So you can see the list here. Not a lot of guidance on if you run into these, what should you do? Lack of reporting requirement. If you find money laundering in the course of a financial statement audit, if it's immaterial, you really don't have to report it. Again, if you do find it, I would still contact your own attorney to figure out what to do. But if it's immaterial, according to the auditing guidelines, you don't have to report it. So, very, very interesting. There is the U.S. Patriot Act of 2001, and within it is the International Money Laundering Abatement and Financial Anti-Terrorism Act of 2001. Well, it's a long sentence. The act requires that bank and non-bank financial institutions have anti-money laundering policies and programs in place. Okay, so you're required to do this as part of this act. And you can read through this. And there's another act. Here it is. Very recent. And this requires millions of corporations in the U.S. to report the true owners of anonymous shell companies to the federal government for inspection by law enforcement and compliance officers. Okay, a lot of burden is placed then on U.S. corporations. But look at this. Some loopholes someone has identified. The law may not apply to certain hedge funds. The law exempts firms with more than $5 million in revenues and more than 20 employees. Interesting. Certain charitable, semi-charitable trusts are exempt. and look at the others. So it seems like these so-called loopholes sort of water down the purpose of the act. Well, one more point of it. It does establish a whistleblower program, and whistleblowers provide information that leads to an enforcement penalty of more than $1 million may be eligible for a reward as high as 30% of any amount collected. Okay. A little bit of whistleblower incentive there. Very interesting. All right, that's the end of Chapter 7. So again, read through it in detail yourself, and as always, good luck with your studies.